Hello, friends, and welcome to another WSIB Truth Matters with Joe Machado. I hope you're doing well today. In this episode, I'm going to talk about Section 147 supplements. These are supplements that would apply to claims or injuries or diseases before January 1st, 1990. The reason why I'm going to talk about Section 147 supplements is that it's always been a bit of a source of confusion among injured workers, and rightfully so, because the board was less than consistent back in the mid to late 80s when they were awarding these supplements. They were inconsistent in how they were applying the eligibility process, and then they became even more inconsistent when they were conducting the legislative reviews. And so a lot of injured workers got screwed over this. Over the years, with my paralegal firm, we handled hundreds of these cases and were able to restore quite a number of them. So I wanted to talk about this because there's still a lot of people out there that I know were either receiving the supplement and had it illegally taken away by the WSIB, or were eligible for the supplement but never had a proper eligibility review conducted. So they basically went on without having that benefit to which they were really entitled to. And so I'm going to talk about the eligibility process for the Section 147.4 and explain what it is. The 147.4, it's one of the supplements. So I'm going to go over the eligibility, and I'm also going to go over the what the WSIB could or could not do under the law in terms of reviewing the supplements at their legislative review timeframes. So the eligibility process was actually pretty simple, but the WSIB sometimes has a way of complicating things. So if you were injured before January 1st, 1990, to be entitled for the supplement or to be considered for the supplement, one of the requirements was that you had a permanent impairment, and so a pension. So if you didn't have a permanent impairment, then you wouldn't be part of the eligibility process or review. The other factor is whether or not you, with a permanent impairment and permanent restrictions, if the worker was able to return to their pre-accident job at no wage loss. Once it was determined that the worker was not able to return to the pre-accident job at no wage loss, and that the employer would not be able to permanently accommodate the worker in their pre-accident job, the employer could provide a modified job if one was available. If that modified job did not pay the same wages as the pre-accident job, then the Section 147.4 supplement would be paid as a wage loss. That would be a Section 147.4 supplement. I'll come back to that one. If the employer was not able to provide employment in the pre-accident job or in an accommodated position on a permanent basis, then the worker would be referred to Vocational Rehabilitation Services, which is now called Work Reintegration Services. And the main purpose of Vocational Rehabilitation Services was to assist and support the worker in returning to a job that was suitable to his or her restrictions, that was within the worker's skill set, and that came as close as possible to the escalated pre-accident earnings. So in other words, if you were earning $15 an hour at the time of the injury, and the employer couldn't accommodate, WSIB Vocational Rehabilitation Services became involved, their objective was to help the worker return to a job that was suitable, for which the worker had the skills, and that came as close to as that $15 an hour as possible. There were many instances where the WSIB would do or refer the worker to a psychovocational assessment, which is something that's done to this day, to help identify potential vocational goals. They're now referred to as suitable occupations, to help the worker return to employment. And at times, the WSIB would provide retraining if the worker met all of the qualifications. And this is where it gets a bit tricky when dealing with or understanding the eligibility process. So there are often times where if the WSIB did not think that through vocational rehabilitation services, the person would be able to, with retraining, mitigate or fully mitigate or approximate their pre-accident earnings through vocational rehabilitation services, they would award a Section 147.4 supplement, which at the time was paying, I believe, $383 or $87 a month, and each year it's increased. So now it's well over $450 a month. This is if they made a determination that they couldn't assist the worker in returning to work, even with the assistance of vocational rehabilitation services, to the extent of approximating their pre-accident earnings. This often happened with individuals who earned significant income, so they were considered high-wage earners, predominantly in mining or the construction industry or in industrial settings, where the individual didn't necessarily have a whole lot of education in terms of academic skills. A lot of individuals who couldn't communicate the language well, and the board didn't believe that supporting them through 2, 3, 4, 5 years of a retraining program would get them to a point where they could approximate their earnings. So if they were a high wage earner and earning, let's say, $30 an hour in construction, and with their restrictions and limitations, and then taking into consideration the lack of skills or academic background, they would make that decision. If, on the other hand, the WSIB, through that psychovocational assessment, determined that there were some vocational goals that, given the worker's profile in terms of personal skills, level of education, and also taking into consideration the restrictions for the injury, if that psychovocational assessment was able to yield some vocational goals that required retraining, and I saw the WSIB pay for retraining for 3, 4, 5 years of academic upgrading, college, and even university programs. If that were the case, and the WSIB agreed that they could assist the worker through a program, then the worker would be entitled to a Section 147.2 supplement. The difference between the 147.2 supplement and the 147.4 supplement is quite significant. The 147.2 supplement was paid in conjunction with the pension that was assessed for the disability. And so the pension, let's assume that the pension was 20%, and the WSIB would then pay the 147.2 supplement, which would make up the difference. So the pension combined with the 147.2 supplement would be equivalent to the pre-injury earnings. And that supplement would be paid for the duration of the vocational rehabilitation program. And after the program was concluded in terms of retraining, it would be paid for an additional period of 6 months of job search training or assistance. And I also saw in a lot of cases, and we were able to get them approved as well, where job search assistance was provided for up to a year. None of that happens today. For the individuals who were not eligible, who were deemed to not be eligible for the Section 147.2 supplement, they were paid the 147.4 supplement, which was a supplement that was basically a fixed amount. It had nothing to do with the person's earnings. And the supplement would, in most cases, not allow the worker to restore or fully mitigate their wage loss. So in some respects, the supplement was a bit of a joke, in that they promoted it as a wage loss supplement, but it really wasn't. That's where when there were amendments to the Workers' Compensation Act under Bill 162, and they came out with the future economic loss system, that became a true loss of earnings benefit. And the same with Bill 99, current cases where loss of earnings benefits are based on earnings. So the supplement under Section 147.4 had two legislative review periods. So the first one was 24 months after the supplement was granted. The second legislative review was 36 months after that. And at that point, it was locked in. So the WSIB couldn't review that supplement for any reason at all. And this is where the train went off the tracks. At the 24-month review, a lot of claims adjudicators, as they're called now, in their infinite wisdom and without any information to back it up, started to revoke the supplement or stop paying the supplement at the 24-month review. By that time, the only thing that had mattered or had transpired in a worker's case was 2 years had elapsed or passed. They'd gotten older, but their injury didn't miraculously disappear, or the effects of the injury. And they didn't have any more education, or their vocational characteristics didn't change in any way, shape, or form. But this is what they did. And they justified that by saying that, well, we believe that you do have the ability to mitigate your earnings. And because you didn't cooperate with vocational rehabilitation services, which is bullshit, because everybody cooperated because they wanted to return to work. And in some cases, they wanted retraining and were denied retraining, saying that they didn't meet the qualifications because their earnings were too high. But yes, a lot of claims adjudicators were doing this, and they were being overturned by the hundreds, if not thousands. And this continued right on to the 36-month review. And so they basically took away a lot of supplements that they didn't have the legal authority to do under the Workers' Compensation Act. And Section 13 of Section 147.13, which is the section that governs and lays out the process for the review, also subsections 9 and 10, which basically stipulates very clearly that the only thing that the WSIB could do at any of the review stages, so the 24-month review and the 36-month review, was to recalculate the supplement if there had been any change in the worker's earnings in the previous 2 years that placed the earnings at closer to or over the escalated pre-accident earnings, in which case the WSIB did have the authority to, if the person's earnings for some reason had increased, so they got a job or some part-time work, and I'm talking about actual employment earnings, if they increased to the point of fully mitigating the escalated pre-accident earnings, then they had the right to take away the supplement or reduce the supplement by any amount that the worker's earnings had increased. Those were the only things that they were allowed to do at the legislative review stages. They went way above and beyond that and basically took it wasn't a significant source of income, but it was at least contributing to the family budget, to somebody who was already at a significant wage loss, and just basically left them high and dry. So we were able to successfully get a lot of them overturned and restored. And so that's one of the reasons why I wanted to do this video, because I know there's a lot of injured workers out there who would have either qualified for the supplement, in other words, would have met the eligibility criteria, and there's some that we're handling currently. And also, there are a lot of injured workers out there who had their supplement pretty much taken away, and they just figured they didn't really have anything that they could do to get it back. So that's not the case. You can get it back if it was done illegally, and you can still qualify for it if they didn't do the review when they should have, and then they're required to pay that. And I can tell you it can go back for many, many years. So I hope that this was informative for some of you. It may not mean a whole lot to others, but it's just one of those aspects of WSIB legislation that the WSIB case managers and even appeals resolution officers were agreeing with case managers, and decision review specialists were agreeing with or claims adjudicators. It was just a free-for-all. Let's screw the injured worker as much as we can. There was absolutely no authority to do that, but they did. So we can get it back. If you find yourself in that situation, then by all means, send me an email at joemachado@wsibsettlements.com, and I would be very happy to review your situation and let you know whether you may still be eligible for it or whether it was taken away and we can get it back for you. Okay? All right, friends, thank you for taking the time to watch this video. For those of you who are new to the channel, I invite you to become a subscriber. It's free. Click the notification bell so you get notified every time I come out with a new video. And as always, my friends, thank you. And till the next time, take care.